Lawyers of Reddit, what's your best most baddest I rest my case moment? As a young attorney, I had stated a claim that an insurance company was dragging out a case in bad faith, in hopes that my elderly client would die before they had to pay him. I was requesting that the trial day be given priority due to my client's advanced age. The judge was no spring chicken himself, and seemed skeptical when he asked exactly how old my client was. Maybe thinking that he was in his 70s and must merely seem ancient to a baby lawyer like me. When I responded that my client was 92, and the case has already gone on for 5 years, the judge was visibly shocked, and immediately granted my motion for priority, shutting down the insurance company's attorney's attempt to respond. They wrote us a check for $1 million the next week. I was representing a woman with a severe neck injury. Opposing counsel presented a test result that showed her cervical exam was normal. I felt almost bad when I pointed out he had the wrong cervical area in mind. We had a case where opposing counsel was cross-examining our expert witness on hydrology regarding some silt runoff issues. Mr. Smith, wouldn't you agree that the book I'm holding is highly respected in your field and considered to be the gold standard on the subject? Witness, I am aware that it is highly regarded in my field. Would you be willing to explain, in your own words, what paragraph 6-10 on page 121 is describing? Witness reads the passage word for word. Yes, I can read. But could you put this passage in your own words for the court? Witness, these are my own words. I wrote it. We were the defendants. We were being sued by Idaho over silt in a lake. We were able to prove that we weren't responsible and prevailed. It actually originated from another site and entered the lake elsewhere. However, that site was owned by a very large corporation and I don't think the HOA wanted to fight with an entity that could fight forever. My sister got T-boned by a car, causing a concussion when I was younger. Long story short, we were in court with the judge, who asked the driver if he had ever sped before. No, Your Honor. I never speed, was his reply. The judge asked him a couple more times if he was sure. If he never sped. Ever? The driver was adamant that he never sped and never had before. A few minutes later, my sister's lawyer gave the judge some paperwork. She read it and said to the driver, "It seems that you have some past driving violations. Can you tell me what they are for?" Speeding. The driver had to pay medical bills for my sister. Corporate lawyer. So I don't have cases to rest. But once opposing counsel was forcefully insisting that it was ridiculous for me to expect a certain provision in a contract we were negotiating. And I pointed out that this provision was standard in his own firm's contract forms, as I knew from several prior transactions I'd worked on across from them. Pretty exciting stuff. He took it in stride and said, jokingly, "Well, of course it's fine when we ask for it." A lawyer friend of mine had written a blog post about a legal subject. Opposing counsel filed a motion, again. As others pointed out, this is like the small battles which are part of the overall war of the lawsuit, in which they had to cite their reasoning for their arguments. In this particular motion they chose to dig through the website of my friend where they found that blog post which they chose to cite in their own arguments. Basically, they were going for an aha moment. You can't argue against us because you yourself once wrote something which we think agrees with our point of view, rather than dispute the nitty-gritty details of their argument. My attorney friend simply responded with something along the lines of, "I am honored to be cited as an expert in this area by my esteemed opposing counsel. Now, as their chosen expert, let me tell you what the law means and why they are wrong." It was glorious. They very quickly revised their argument. I represented a company that was sued for breach of contract by a former independent contractor. Dude basically alleged that my client wasn't paying him correctly in accordance with the contract. During his deposition, dude admits that he never reviewed any documents to make sure his allegations were true. Never reviewed his complaint before filing it to make sure the allegations in it were true. and had no idea whether or not my client actually failed to pay him in accordance with the contract. Basically, he tells me that he was suing my client because he didn't think their agreement was fair, even though he agreed to the terms when he signed the contract. The kicker is that he admitted that he owed my client money. At arbitration, he tries to flip his story and starts giving testimony that is the exact opposite of his dep. So I whip out his transcript and undermine his testimony bit by bit. Needless to say, I won that case. Not a Oscar case winning moment, but awesome motion winning one for sure. Think of cases like a big conflict, with motion hearings as little conflicts. Opposing attorney was insisting that Aussie Rule A meant they could do X. I tried multiple times to point out Aussie Rule A literally did not say that. During the hearing, the judge reached behind them, grabbed their Aussie Rules of Civil Procedure, basically a dictionary of rules, placed it in front of the other attorney, and said, "Show me where Rule A says X." The other attorney did not take the hint, read rules out loud for a brutal 5 minutes, and gave the book back. I said, "Judge, I have nothing to add." It was pretty fun. Opposing counsel decided that I had coached my witness and gave him lines to repeat, that he was lying. Short version is that he asked the witness if he spoke to me before he testified. Witness said he had. Attorney looked like he thought he had me. Attorney asked the witness what I told him, what instructions I gave him. Witness looked him dead in the eye and said, "First thing he told me was to tell the truth no matter what." He said the lawyer is never the one who goes to jail. That he isn't going to jail for me. And if I lie, I'm on my own. Attorney looked like someone took the air out of him. Everyone in the courtroom simultaneously looked at me. Only time I've smirked or laughed in court. I wanted to put my feet up on the table like I was Vincent LaGuardia Gambini, hands behind my head, and say, "I'm done with this guy." I was on the losing end. Represented a guy who had bought a company and the company failed spectacularly within months due to a number of reasons I could attribute to the seller. And they had clearly lied about the company's finances to induce him to buy. I was suing to rescind the deal, have your TTY company back and give my guy his money back. I laid out my huge case and thought I had it in the bag. And then opposing counsel asked my guy, "Isn't it true that you listed this business for sale a month ago?" "Yes, and you did sell it, correct? You signed a purchase and sale?" "Yes, but he never finished paying me. He has more payments to make. I'll just give his money back when you guys give me my money back." My idiot client had me suing over a company that he had legally sold. FK never told me. Game over on the spot. I'm not an attorney, and it wasn't in front of a judge. But I got into a dispute with a contractor who FK'd up royally when installing a new heating system, resulting in an asbestos contamination of my house. Their insurance argued the contractor couldn't have caused the contamination, because the contamination was way worse than could have been possible from what the contractor did, which is bullshit. They argued the contamination must have been caused by the contractor that installed the previous heating system. It was super satisfying to write our response. 1. The previous heating system was placed 12 years earlier. The asbestos dust was visibly lying everywhere. Arguing we didn't vacuum for 12 years was beyond ridiculous. 2. The asbestos dust was on a floor we installed 6 months earlier, included the receipt for the floor. And then the third point was the most fun to write. 3. I said they were welcome to believe the contamination was caused by the contractor who installed the previous system 12 years ago. I included the receipt of that installation. It was done by the same contractor. The next letter was very brief, stating they would pay us for all damages we were claiming. Not a lawyer, but during a particularly nasty employment mediation hearing, I got to ask my former employer a question about payments per employment law. Me. Did you or did you not pay into state mandated unemployment insurance fund for all your employees past and present? Silence. Mediator. Sir. Answer the question. Silence. Mediator. Well, let me ask it. Did you or did you not pay into state mandated unemployment insurance fund for all your employees past and present? Silence. Mediator. When I was in law school, I had to argue a case for an exam. I was the last in my class to go, so there wasn't anyone arguing against me. I opened with a motion to dismiss since opposing had failed to show. The judge grading me chuckled and said, "Touché, counsel." I still had to go forward, but we got off on the right foot and I ended up with an A. Complaining witness accused my client of harassment stalking. Said she told him numerous times that she wanted nothing to do with him. My client claimed they were dating. But whenever she got mad at him, she'd call the police and say he was harassing her. On the stand, she testified that she'd never dated him, never invited him into her home, wanted nothing to do with him. She presented a photo on her phone of him sitting on her porch to prove that he had come to her property. I asked the judge permission to look at the photos before and after the porch photo for context. Girl had dozens of photos of the guy, who was clearly her boyfriend. I showed her one such picture. "This is MR. So and so. Right? Yes. In this photo. He's on a bed. Yes. The bed is yours? Yes. The bed is in your bedroom? Yes. You took this photo of him? Yes. He's smiling in the photo? Yes. And in this photo, he's wearing your brassiere? Yes. No further questions, Your Honor. I was prosecuting some kid. He had an antisocial behavior order, which meant that he was not supposed to go to a certain street. He had pleaded not guilty on the basis that he had not been there. I opened my cross-examination by holding up a map and pointing at the street. I said to him, "You went here, didn't you? Full stop." He said yes. In England, we don't say "I rest my case." Instead, I looked up at the bench, said no further questions, and sat down. It might not seem badass, but I got the defendant to admit the offense with one question. That never happens. Defendant in a bench trial for a speeding ticket said he couldn't possibly go as fast as the officer clocked him. He knew this because he videotaped himself accelerating from a full stop to the location of where the officer sat. His experiment showed his vehicle could only get to 55 miles per hour and not the 67 mile per hour he was clocked at. The ADA then moved to have another speeding ticket issued because the actual posted speed limit was 50 miles per hour. 5 miles per hour over is probably just a fine and a few points. IP lawyer, deep in a set of terms and conditions on a website. Our client's details, name and contact details, were listed. So it is very evident that they just copy-pasted our client's legal terms and conditions and missed a couple of details they needed to change. I was handed the matter. Did a quick Ctrl+F for client details. And it was an open and shut case. Not really that impressive, but saved me hours of time going through each term one after the other, noting exact similarities for a letter of demand. Terrible people had stolen all of this little old lady's money. They said it was a gift, but their only evidence was a document in the bad person's handwriting that was allegedly dictated. It said September 2012. No day, just the month. Clearly the rogue had forged that when she found out about the lawsuit, and not remembering when she had stolen it, she hoped if she could guess within the month no one could challenge her. So I'm questioning her about it. Exhibit B is the little old lady's bank record. Now that withdrawal at the bottom. Is that the alleged gift? Yes. Can you read the date of that transaction for me? The 25th of August, 2012. Thank you. Pro bono case. Representing woman who was trying to get a permanent protective order against her boyfriend. I ask her if he has contacted her since the temporary order was issued, which is a crime. She says yes. He called her 3 times. Defendant. Objection, Your Honor. Judge. State the grounds for your objection, please. D. The facts. I only called her once. Me. Obligatory, not a lawyer. But I was defending myself against a debt collector for a debt so old I could not even remember for sure that it was mine. Me to the debt collector. Can you provide the actual contract bearing my signature along with a chain of title to the debt? Debt collector's lawyer. Crickets. I look at the judge. Judge to lawyer. Well, can you? Debt collector's lawyer while looking through paperwork. Well. No. Not at this time, Your Honor. Judge. Case dismissed. Note. To prove that a debt collector owns your debt, they must prove how it came to own it. Often, old debts are sold and resold over and over again to a number of subsequent debt buyers. When this happens, the debt collector must prove each and every assignment by showing a chain of title reaching all the way back in history to the original creditor. More often than not, for old debts, it is impossible for the collector to show this. I represented a poor woman whose husband left her and their child behind. He was of course unemployed. He did not want to pay and started his plea with how much he loved his child but couldn't afford anything. I started to laugh, which was of course a bad move of me. The guy, his lawyer and the judge stated that it was unprofessional for me to laugh. I luckily came back, presented his rental bill, petrol bill and phone bill, together forming 2 times his welfare check without his daily bar tab. So we can only conclude he has a job in black, and that he chooses not to pay for his beloved child. The judge looked at him. He couldn't reply and we finally won with him needing to pay 1.5 times his welfare check to his ex-wife. Sadly, he fled to North Africa to escape the sentencing. In the state of New York, if you are issued a citation for a traffic violation, you are allowed to request a supporting deposition, which is essentially the officer swearing that he saw you violating whatever law you broke. The courts must supply this SD within 30 days of your request or you can motion to dismiss the case. On traffic violations where the SD isn't supplied by the officer at the time of the citation, there's a box you can fill in where you can request one. I filled mine in with black pen and went down to the courthouse. I handed the citation to the clerk and asked for a reschedule of my court date to more than 30 days out because I was going out of town. No SD was supplied to me. I showed up and motioned to dismiss and the judge was legit proud of me. His words were, "I'd never look down on someone for successfully navigating the legal system." Dismissed. I once had an appeal where the precedent, all from other circuit courts, was very bad for me. The circuit court I was arguing in front of had a decision that was very good for me, but it wasn't published, meaning that it was not precedential. My goal was to convince the court to follow its unpublished decision, not the decisions of the other circuits. During my argument I cited the unpublished decision. One of the judges interrupts me and asks, "But wasn't that decision unpublished?" I answered yes, but it was well reasoned. He replied with a self-effacing quip, "I was on the panel for that decision, so it couldn't have been that well reasoned." The audience laughed a bit. I answered quickly, "In that case, Your Honor, it was at least well written." The audience, and all the judges, burst into laughter. I ended up winning in a published decision, which turned the old unpublished decision into binding precedent. A bit of humor can go a long way in the courtroom, especially when you're flattering the judges. Once had fairly standard RTC case. My client going round a roundabout in a small car got sideswiped by a lorry driver. Claim for damages, loss of earnings and the rest. Other side's entire case rested on whether the lorry driver saw my client or not, as we could prove from CCTV that my client was well within her lane, within speed limits and generally on solid ground legally speaking. Their client gets into the witness box and is asked if he saw my client. While you can't ask leading questions to your own client, a napkin could tell he was being prodded towards saying no. The man promptly responds, I did. But the bitch shouldn't have been where she was. My cross-examination consisted of getting him to repeat that answer and then sitting down. To date, the easiest day in court I ever had. Divorce attorney. I had a client with a son who, at 9 years old, was testing at college levels. Mother was always an obstructionist. Verbally emotionally abusive. Refused to allow him to take even high school caliber classes. Private tutors with just advanced subjects, citing she couldn't afford it. Husband offered to pay everything. Cue the "you are manipulating our child against me" cries. Judge denies advanced placement for the child. Judge denies sole custody despite documented emotional abuse, slamming doors in his face. Calling him a literal loser for wanting to study. etc. Fast forward a few years. Kid gets interviewed by evaluator and says he'd be fine never seeing his mom again. She cries to the court in a hearing that she couldn't afford, emotionally or financially, the toll of not being with her son. Unbeknownst to me, the son pipes up that he has a picture of his mom's handwritten invoices from her work showing she's pulling in 4x the money she tells everyone about. Semicolon. I literally just stood there and won because some kid had his iPhone glued to his hand. I was in a gang-related jury trial for attempted murder. Defendant was a known crip and the victim was a blood. Against his attorney's advice, the defendant testified. Defendant had a tattoo on his arm that said BK. I asked him what BK meant and he replied with blood color. I was shocked he said what it actually meant. But in retrospect, I guess I shouldn't have been since he actually decided to testify. So I typically do plaintiff's work for corporations, but one of my clients was getting sued by a former contractor for work allegedly performed right before he was fired in the amount of $150K. I had never dealt with opposing counsel. She was about my age, 32, and seemed nice heading up to trial. The day of our pre-trial, just 5 days before trial, she tells me in the elevator, "I hope you know I'm going to kick your ass in trial." I laughed and she said, "No really. You are screwed." Trial comes and she drags out her case over 5 days and I start to get the impression her client made up the invoices with her help. She finally rests her case and I called her client as my only witness. He immediately testified his attorney showed him how to make the invoices. The judge wouldn't allow them into evidence. She lost her case and was sanctioned $5K for falsifying evidence. She appealed and the Court of Appeals ripped into her. Needless to say, I didn't get my ass kicked.